We will hear argument this morning in Case 23-939, Trump versus United States.
The Supreme Court heard oral arguments to decide if former President Donald Trump is immune from criminal prosecution for his alleged crimes in trying to overturn the 2020 election results. This is the Jack Smith case out of Washington, D.C., related to January 6th. Now, a grand jury indicted him in August of 2023. Here is the opening argument from Trump's attorney, John Sauer, whose arguments that we've heard time and time again from Trump, that a president has to be immune from everything. He could be able to commit any crimes. His argument is full of holes, my friends. You could drive a Mack truck through the holes in his argument. Here he is.
Mr. Sauer?
Mr. Chief Justice, and may it please the court. Without presidential immunity from criminal prosecution, there can be no presidency as we know it. For 234 years of American history, no president was ever prosecuted for his official acts. The framers of our Constitution viewed an energetic executive as essential to securing liberty. If a president can be charged, put on trial, and imprisoned for his most controversial decisions as soon as he leaves office, that looming threat will distort the president's decision-making precisely when bold and fearless action is most needed. Every current president will face de facto blackmail and extortion by his political rivals while he is still in office. The implications of the court's decision here extend far beyond the facts of this case. Could President George W. Bush have been sent to prison for obstructing an official proceeding or allegedly lying to Congress to induce war in Iraq? Could President Obama be charged with murder for killing U.S. citizens abroad by drone strike? Could President Biden someday be charged with unlawfully inducing immigrants to enter the country illegally for his border policies? The answer to all these questions is no. Prosecuting the president for his official acts is an innovation with no foothold in history or tradition and incompatible with our constitutional structure. The original meaning of the executive vesting clause, the framers' understanding and intent, an unbroken historical tradition spanning 200 years, and policy considerations rooted in the separation of powers all counsel against it. I welcome the court's questions.
Now, Attorney Michael Drebin from the Justice Department is the legal counsel to Special Counsel Jack Smith. They have been trying to prosecute Trump for his part in January 6th insurrection and other crimes. Now, Trump has been using all of his money and, frankly, the money of his cult followers, some of whom can't afford this. He's been using all of his power to delay. Here are the opening arguments from Attorney Drebin.
Mr. Chief Justice, and may it please the court. This court has never recognized absolute criminal immunity for any public official. Petitioner, however, claims that a former president has permanent criminal immunity for his official acts unless he was first impeached and convicted. His novel theory would immunize former presidents for criminal liability for bribery, treason, sedition, murder, and here conspiring to use fraud to overturn the results of an election and perpetuate himself in power. Such presidential immunity has no foundation in the Constitution. The framers knew too well the dangers of a king who could do no wrong. They therefore devised a system to check abuses of power, especially the use of official power for private gain. Here, the executive branch is enforcing congressional statutes and seeking accountability for petitioners' alleged misuse of official power to subvert democracy. That is a compelling public interest. In response, petitioner raises concerns about potential abuses, but established legal safeguards provide layers of protections, with the Article III courts providing the ultimate check. The existing system is a carefully balanced framework. It protects the president, but not at the high constitutional cost of blanket criminal immunity. That has been the understanding of every president from the framing through Watergate and up to today. This court should preserve it. I welcome the court's questions.
Now, the Supreme Court was tasked to answer one simple question. Is the former president immune from criminal prosecution? The conservatives on the court, the right-wingers, the ones who are anti-democracy, who don't follow the law unless they feel like it, didn't seem to want to answer that simple question. They were all over the place. Frankly, it was disgusting. You could see right through them. Now, the Chief Justice, John Roberts, who sometimes sides with them, he seemed to be among at least 5 members of the court who didn't seem to embrace the claim that Trump, or a president, doesn't have absolute immunity. And that decision, that absolute immunity, would stop Special Counsel Jack Smith's prosecution of Trump. But, and here's the big fat but, the arguments lasted more than 2.5 hours. Roberts also seemed to be among the justices who suggested that this case might have to be sent back down to lower courts before any trial could begin. And here's his argument. He indicated he was unhappy with the reasoning adopted by the federal appeals court that ruled against Trump. Now, this appeals court ruling was brilliant. I produced a podcast on it. Please listen to it again. I'll include the link. Unbelievable. Basically, the bottom line, the appeals court said, the president swears to uphold the Constitution. How can he break laws that the Constitution prohibits? I mean, I'm paraphrasing, but you get it. There are a number of worst quotes from the Nazi justices who want to overthrow the government, and they become full circle, full MAGA. Especially Clarence Thomas, whose wife was involved in the coup. He should be recusing himself. How this is allowed, how Justice Roberts doesn't have the backbone to tell one of his justices, maybe you should sit this one out because your wife is involved in some of this mess. Maybe you should just recuse yourself. Oh, no. Just let him do whatever he wants. Just whatever he wants. We need Supreme Court reform, my friends. We need it, and we need it soon. You know what? I changed my mind. I'm not going to read some of their stupid reasonings on why they should rule for Donald Trump. It's ridiculous. It's ridiculous. But I'll end with this. Here are a few of the things that Donald Trump's lawyer says a president ought to be immune from prosecution for doing. Okay? Selling nuclear secrets. Oh my God. If anybody else did that. And, hint, hint, what's he being charged with down in Florida in the classified documents case? There were nuclear documents in some of the documents that Trump stole and refused to give back. Oh, yeah, but here, they want him to be immune from this. Here's another one. Employing the United States military to assassinate a political rival. Oh, he can just assassinate people. Oh, shoot. And Trump has already said right out there, he wants revenge. He wants revenge. He wants to be able to do this. He wants to be able to get rid of his enemies, his political enemies. He's right out in the open about it. And the other thing he shouldn't be prosecuted for is launching a coup. Been there, done that. Yeah. It was just, I don't know. Why we're even having this, why we're even doing this is astonishing to me. Why Trump hasn't been tried for these crimes he's committed is stunning to me. And that these justices, these right-wingers that were put on the court by Trump that are obviously crooked and in the pockets of who knows, God knows who, Russia, are trying to make excuses for him. And they're going to rule from the high court, the highest court in the land, that this dude should get away with this stuff. Yeah. These actions should be considered official acts, and no current or former president should be charged with crimes for doing them. That was his argument. I will end with a brilliant soundbite from my favorite justice, Ketanji Brown Jackson. I feel like I know her. I covered all of her confirmation hearings. She's just has been such a great addition to the Supreme Court. I'll end with her soundbite when she talks about, she doesn't say this particularly, but if we do this, we're going to open Pandora's box to have the White House become a crime center, which is what Trump's already done when he was president. His family just benefited from working in the White House and have billions of dollars from foreign governments, that son-in-law and that daughter. Here's Ketanji Brown Jackson.
I don't understand how the president stands in any different position with respect to the need to follow the law as he's doing his job than anyone else.
He is required to follow the law. And what
But he's
Fitzgerald
not.
said is
If there's no criminal if there's no threat of criminal prosecution, what prevents the president from just doing whatever he wants?
all the structural checks that are identified in Fitzgerald and a whole series of this court's cases that go back to Martin against Mott, for example, impeachment, oversight by Congress, public oversight. There's a long series of them. Fitzgerald directly addresses this in the civil context, and we think that language naturally ports.
I'm not sure that's much of a backstop. And what I'm, I guess, more worried about, you seem to be worried about the president being chilled. I think that we would have a really significant opposite problem if the president wasn't chilled. If someone with those kinds of powers, the most powerful person in the world, with the greatest amount of authority, could go into office knowing that there would be no potential penalty for committing crimes, I'm trying to understand what the disincentive is from turning the Oval Office into, the seat of criminal activity in this country.
I don't think there's any allegation of that in this case. And what George Washington said is, what Benjamin Franklin said is, we view the prosecution of a chief executive as something that everybody cried out against as unconstitutional. And what George Washington said is, we're worried about factional strife, which will.
No, I'm also, let me put this worry on the table. If the potential for criminal liability is taken off the table, wouldn't there be a significant risk that future presidents would be emboldened to commit crimes with abandon while they're in office? It's right now the fact that we're having this debate because OLC has said that presidents might be prosecuted. Presidents from the beginning of time have understood that that's a possibility. That might be what has kept this office from turning into the kind of crime center that I'm envisioning. But once we say no criminal liability, Mr. President, you can do whatever you want, I'm worried that we would have a worse problem than the problem of the president feeling constrained to follow the law while he's in office.
Finally, this closing comment. Vote. Vote. We can no longer count on this Supreme Court to follow the constitutional rule of law and save us from anarchy, more violence, or worse, a dictatorship. The conservative justices on the Supreme Court are a disgrace. I'm Gloria Moraga, political woman. Thank you, Justice Jackson. And thank all of you for being here. Please subscribe. Please follow me. I don't know if TikTok's going to be around by the end of the year. Who knows? But please follow me there. Follow me on YouTube. I need your support. Follow me wherever you get your podcasts. And most importantly, be safe.